What I intend to do is talk as was foreshadowed for about 40 minutes and then to join Kumar for a conversation. Um, Now, the talk as originally proposed was given the title Public Interest Litigation in India, Time to Rein in an Unruly Horse. Now, if I was minded to be less provocative, I would have added a question mark at the end of that title. But anyway, as often happens, and I don't mean this at all as a criticism of the good folks at BIC, the editors worked their magic and gave it a slightly different twist, the title. The reason I mention this is to lay my cards on the table. I am not a fan of PIL as practiced in India. I'm very happy afterwards to be challenged on this. Metaphorically speaking, I bear many scars on my back for the views that I have expressed on this subject on many platforms. I'll try to keep the discussion as focused as possible, and for that reason, I have taken a slightly unusual measure of putting down a few bullet points to which I shall speak, mainly to keep the talk within manageable bounds. Now, let me acknowledge at the beginning that public interest litigation in principle is a force for good. I cannot deny that. Uh, it arose out of noble objectives, and it is particularly relevant in societies that are scarred by poverty, illiteracy, human exploitation, corruption, more importantly, maladministration, etc. And I also acknowledge that PIL is capable of delivering certain immediate benefits. For example, increasing access to justice for disadvantaged persons and groups as well. Um, it has the potential to clarify the law in areas where legislative intervention could have been um, more vigorous. Um, it can sensitize judges to the felt needs of society where such sensitization is called for. And it can also serve to deal with potentially sensitive issues which need urgent attention and which politicians are afraid to deal with for obvious reasons. PIL obviously has certain long term goals as well, in terms, for example, of achieving systemic social change, breaking down some of the retrograde structural barriers of conventional litigation, and redressing deep rooted inequalities in certain societies. Those are, if you like, the potential long term benefits. Um, but my thesis is that all this comes at a cost, especially when PIL is practiced irresponsibly, indiscriminately, and without discipline, as it has been in India. And the cost often overshadows the actual or anticipated benefits. So, in short, my message is that PIL should be used responsibly with circumspection and in very limited circumstances. I would add as well that it should be used with great finesse, all of which I fear is not happening. I'm not going to spend too much time on historical background, but just to say that PIL in its modern form is a relatively new concept. It's about half a century old, and it, of course, had something to do partly with the injustices of the emergency, 1975 to 77. Um, but no less importantly, PIL had to do with the guilt of some judges for having turned a blind eye to those injustices. Um, but it needs reminding ourselves that PIL was not unheard of earlier, although it did not carry that label. So, at least those of you who have had some familiarity with Western India, in particular Bombay, will remember a case brought by a rather colorful politician called Pilu Modi, um, in which he challenged the government's policy of leasing very valuable plots of land to certain parties at a gross undervalue in what came to be called Nariman Point in Bombay. Um, and this litigation was initiated in spite of the fact that the petitioner, Pilu Modi, himself had no personal stake in the litigation. So you could think of it as one of the first cases of PIL. Of course, PIL got a boost immediately after the emergency, mainly through letters, especially from academics, to named judges on the Supreme Court, drawing attention to inequities. For example, the Sunil Batra litigation, which concerned ill treatment in jail, and the Hussainara Khatun litigation, which had to do, I think, with disproportionate detentions without trial. And then, of course, PIL evolved. I have to say, in fairness to the earlier judges, that they were fairly cautious, confining PIL petitions to cases of poverty, helplessness, or disability or social disadvantage in people who could therefore not approach the court themselves. Also, um, only in situations where legal wrongs or legal injuries had been caused to a person or a determinate uh, class of persons, which resulted in a violation of their constitutional or legal rights. And the relief sought were such that they could be awarded within reason under Articles 32 or 226 of the Constitution of India. The rules on standing, what lawyers technically call locus standi, were of course relaxed. They were relaxed in favor of the poor and the downtrodden, the poor and the disadvantaged, or deprived and disadvantaged people. These were the phrases used in the early litigation. And of course, a particular focus of the earlier judges was people who had been deprived of liberty, personal liberty. Um, the the concept of standing was at that time confined, or at least the the impetus of the litigation at the time was towards convicted prisoners, women in protective custody, children in juvenile institutions, bonded migrant laborers, unorganized laborers, untouchables, and scheduled tribes, etc., etc. But then you see something happened, which, to my mind, was unfortunate, and that is that this limited focus gave way to what came to be called citizen standing. Any person was allowed to bring a case in what was called the public interest, regardless of whether or not um, he has himself suffered any injury or whether he represented a class of people who have suffered such injury. Now, of course, what was in the public interest was left entirely to the discretion of the court, which also I think is a dangerous thing to do. And there were a number of justifications offered for the new approach. The essential filters in the matter of locus standi were removed, um, which opened the floodgates to uncontrolled litigation, including by, I'm sorry to say, vexatious or ill motivated busybodies. That is a reality which cannot be ignored. Simultaneously, the nature of the proceedings were allowed to be altered radically. The task of establishing the facts in a dispute and of collecting relevant evidence um, to support the contentions made by the petitioners uh, would no longer fall exclusively on the parties, but would be a so called collaborative exercise between them and the judges, which goes against the grain of the common law system. This innovation was justified on the premise that the standard adversarial nature of legal proceedings was perceived as the enemy of access to justice. The judiciary, said one famous judge, Bhagwati, who was pushing for this change with unrestrained ideological zeal, cannot remain content to act merely as an umpire, but it must be functionally involved in the goal of socio-economic justice. I profoundly disagree with this statement. It's not the function of a judge to engage in a crusade for socio-economic justice. If he wants to do it, he better join a political party, contest the elections, and if he is successful in persuading a majority of people of the rightness of his cause, he's very welcome to engage in that sort of a crusade. Anyway, just to continue with the evolution of PIL, um, any objection that was raised to the admissibility of evidence which had not been tested by cross examination, for example, was given short shrift. This was not only unfair to the respondents, to the defendants in a given case, but it also meant that the petitioners were reduced to the position of informants who did not have the onus of proving their case. And the next unfortunate step was for the court itself to assume the role of petitioners and initiate proceedings under what has come to be called the suo motu jurisdiction. So the judges began relying on media reports of injustices in various corners of India, of which, of course, there's no dearth. At the very least, this reflected an impatience with due process. And at worst, I would suggest it smacked of judicial arrogance. It led to the court to assume multiple roles, including those of investigator of facts, mediator, counselor, depending on the nature of the issues raised in a given case, when, generally speaking, it has neither the expertise nor the resources to embark on complex fact finding exercises beyond what can be achieved through pleadings. And I would say that it did not have the mandate, the judiciary did not have the mandate either to embark on such expeditions. And then there was another phase when the concept of PIL took on a new dimension, which involved the appointment of amicus curiae in many cases. And disturbingly, the Supreme Court gave these individuals ever expanding powers, including to formulate policy and to administer institutions, which was clearly an unacceptable outsourcing of the judicial function. And no less worrying was the, I would say, rather cavalier approach adopted by many judges in the fashioning of remedies. They passed orders which were excessively wide and also excessively prescriptive, and which required long term monitoring, which, given the huge pressures faced by the courts, was unrealistic. Occasionally, orders were passed which affected parties who had not been heard in the proceedings. I would add as well that outrageously, in a few cases, interim orders were passed which had the effect of prejudging the outcome of the cases. If memory serves, there was a case in, I think it was in Delhi, 1985, what was called the oleum leak case, where a slew of directions were passed, including designing a victims' compensation scheme, all of which I submit would not fall within the jurisdiction of a court. Um, Perhaps the most serious shortcoming of PIL is that the courts have all but ended up usurping the powers of the executive in many areas. In other words, we are talking about something very important, the separation of powers doctrine, on which democracies like India rests. Some judges have gone so far as to, in effect, direct the executive branch of government to take steps to legislate on various ills highlighted in PIL cases. For example, there was one which involved directions to stop ragging, as it's called in India, in colleges and universities. Although, in fairness, I have to say that I think that judgment was overturned in appeal. At another level, courts have entered into sensitive areas of public and sometimes private policy, which it has no business to enter, such as when dealing with faith-based matters. And a prominent example of that would be the Sabarimala dispute, which was what, 2018-22, or financial matters. For example, there was a case where the court declared that state-owned railways cannot make more than a marginal profit in its operations. Another example would be the court questioning the wisdom of the state's specialized agencies on school syllabi. Now, in one case decided in 2021, the Kerala High Court issued a show cause notice to the government asking why it should not pay for the importation of a certain drug, medicine, which the parents of a sick child could not afford. Now, don't misunderstand me. I'm not lacking in sympathy for the child or for children in such circumstances. It's simply that I'm questioning whether the court is the right forum for these kinds of orders. In another case, the Delhi High Court entertained a plea from the mother of a young man who was hospitalized in Australia to direct the government to supervise the medical treatment and to try to obtain a visa for the mother to travel to Australia. not at all what a court should do. Um, Another worrying aspect of the way PIL has been run in India is that the courts have created new rights where the creation of such rights is highly debatable, um, perhaps unjustified. And this development also goes against the separation of powers doctrine. Um, if you look at the number of so called derived rights that have been carved out of just one article in the Constitution of India, Article 21, the right to life, uh, it is both mind boggling and indefensible by any reasonable standard. To take but a few examples, we are told that the right to life includes the right to food, the right to shelter, the right to livelihood, the right to health, the right to education, the right to freedom from atmospheric pollution, the right to clean drinking water, the right to roads in hilly areas, the right to privacy, the right to a speedy trial for offences, and the right to legal aid. Now, I don't dispute the need for action in any of these areas. All I'm saying is it's not the judiciary's job to do this. And in any case, if the constitution makers wanted these to be included as part of Article 21, they would have said so. Actually, if you look at the Constituent Assembly debates, you will notice that some of these so called rights were explicitly excluded. And in those circumstances, I think it's entirely wrong for the courts to create those rights from nowhere. Now, I'm not sure about this, but I believe that the Karnataka High Court a few years ago suggested that vehicles parked illegally on pavements, on public roads, and other obstructions would amount to a denial of the citizen's right to life. Uh, Now, that is the kind of thing that I think gives PIL a bad name. Um, there's another aspect to all this, which is the personalization and uh, the pursuit of ideological agenda. So the development of PIL in the 1980s was accompanied by uncontrolled ideological fervor, sometimes bias, and a lot of virtue signaling. Um, and those who queried the direction that PIL was taking, I'm talking about the 1980s now, were branded as reactionaries and called old fogies with fossilized minds who find it difficult to reconcile themselves to the new wind of change which is roaring down the ancient corridor. This is one of the quotations from Justice Bhagwati. Worse still, there was also an attempt to pursue personal aims. Bhagwati, again, hugely ambitious and manipulative, was particularly ruthless and, I should add, successful in pushing the PIL project despite his own, shall we say, checkered record as a judge and as a defender of human rights. There was also a lot of grandstanding and point scoring, so much so that other judges were sometimes compelled to give vent to their concerns. I remember Justice Tulzapurkar, um, he couldn't once resist noting in a judgment that prefaces and exordial exercises, peroration, sermons, and also theses and philosophies, political or social, whether couched in flowery language or language that needs simplification, have ordinarily no purpose and no place in judicial pronouncements. Um, and of course, there are no prizes for guessing whom this was directed at. It's worth noting as well that where pious homilies are followed by no concrete results, as sometimes happened, the credibility of PIL is bound to take a knock. Now, what are the substantive questions that need to be considered when we talk about these developments? Even if it is accepted that the intentions behind the encouragement of PIL were good, I think it's not unreasonable to ask a few questions. First of all, whether good intentions alone are sufficient to justify sweeping departures from time tested principles and procedures. Secondly, whether due consideration was given by the PIL crusaders to the long term consequences, both foreseeable and unforeseeable, of what amounted in many respects to a recasting of the entire justice administration system in a fundamental way. Thirdly, whether the unelected judiciary was an appropriate instrument to spearhead and oversee a program of change which involved unsettling, carefully balanced constitutional arrangements, including in relation to the separation of powers between the three main organs of the state. Um, I would submit that any doubts and fears expressed by the PIL skeptics have in fact been realized over the past 3 decades, though that has not made a dent to public perceptions. And it cannot be an argument, I would say, that the nagging political realities in India, this is a phrase used by Professor Upendra Bakshi, require the courts to step into arenas where it should not abide by time tested standards. So these are all very worrying trends in my view. Uh, what also is happening the last few years is that final year law students are filing PILs and arguing the cases as litigants. Now, I have nothing against students getting experience, but surely for them to be asked to also encourage these rather unfortunate trends is, I don't think, a very healthy development. Um, and an increasing number of petitions are asking the court to constitute committees, institute investigations, etc. For example, in relation to the administration of cricket. Um, or also, I think there was one involving the government's disinvestment policy, all of which I feel is an unhealthy trend. Now, preference is being given to PILs, including, in my view, manifestly unmeritorious ones, where millions of ordinary litigants were patiently awaiting the turn to get justice. This is a practical point. I've raised certain policy and philosophical arguments before, but this is a practical point where there's so many people, there are millions of cases pending, and if preference is given to PILs, some of them totally frivolous, then clearly a question can be asked about uh, the judiciary's priorities in terms of expending its resources. Um, Now, on a lighter note, some of you may recall the observations of a former judge of the Supreme Court that 95% of the PIL cases filed in various parts of the country was frivolous and a waste of judicial time. The fact that this observation came from Makande Kaju probably made it go largely unnoticed or treated lightly, which I think is unfortunate. Some judges have been known to make grandiose statements excoriating government agencies. This is not only uncalled for, but also detracts from the dignity of the judicial office. For example, the Madras High Court held that the Election Commission of India had been singularly responsible for the spread of COVID um, by allowing election rallies, and that its officials deserved to be charged with murder for this lapse. It's not judicial language. Um, so there are just quite a lot of serious questions to be asked. I'm going to wrap up my part of the talk so that we can have a conversation now. I'll just spend a minute or two more. There are so many outrageous cases that we read about in the media almost every day. And that then begins to make one think, where are we heading? So, just to give you a few random examples, and I'm not going to spend too much time on this, compiling an exhaustive list will take a lot of time. But there was, for example, a PIL petition which seriously sought a ban on Sardarji jokes involving Sikhs. There was another which sought regulation of beauty contests. A third sought the control of the monkey menace in urban areas, and so on and so forth. And I'm not making this up. These are all cases that actually came to the courts. Now, you could argue that in some of those cases, the courts refused to offer remedies. I'm not disputing that. But the fact that time was spent even discussing such cases is, I think, a matter of, or should be a matter of some concern. So, just to wrap up my talk, I would say that public interest litigation, as developed in practice in India, has had serious negative consequences, almost all of them unintended, but I would say not unforeseeable. And it represents a serious assault on the separation of powers doctrine, which cannot be a good thing for democracy and principled government in the long run. Judicial overreach also has the potential to discredit the concept of PIL itself. It leads and has already led to exaggerated expectations on the part of the public, which can never be fulfilled. Although many of the petitions did not result in the grant of the requested reliefs, the fact that the judiciary allowed itself to be engaged in such unmeritorious pleas in the first place is a reflection of the stranglehold that distorted perceptions of the nature and purpose of PIL enjoy in the public mind. Two generations, I would suggest, have grown up believing that the first port of call for any ills of governance is the judiciary. That is a very worrying trend, in my view. Something happens, let's go to the judiciary. No, that's not how things should be run in a country that believes in the separation of powers. It's also very likely to irreversibly destroy the faith that the Indian masses have placed in the judiciary, especially with PIL being hijacked sometimes by dishonest, thoughtless, or vexatious litigants to either advance private interests or to seek cheap publicity. I think I'll end there and let's have a discussion. Thank you.
First of all, Dr. Iyer, thank you for a very scholarly and very articulate presentation on your side of the case. And I'm sure if this audience were the jury, they would vote with you. Yeah? Okay. I come from a slightly different kind of viewpoint, and I made it very clear to you in the beginning that I'm very positive about PILs. I know there are many negative aspects of PILs, and PILs from being public interest litigations become private interest litigations, become publicity interest litigations, and in spite of all that, I believe I have faith in that system, and I'll tell you why. I think there is a total lack or collapse of governance. And then what happens is that the public generally feel that unless we go to the judiciary, nothing else will happen. And I'll give you a couple of examples there. But before I do that, there used to be a very famous lawyer in Bangalore called Writ Iyengar. So anything that you went to him, he'd say, okay, let's put a writ. Okay, not necessarily public interest litigation, but for anything, he'd say, let's go with a writ. But I'll give you a couple of examples. How many of you are from Indiranagar here? Anybody from Indiranagar? No. Okay. I don't see any hands being raised. You're from Indiranagar? Okay. I'll give a recent example. It may not necessarily be, a strict public interest kind of litigation where it went before a bench. There is a playground near the BDA complex in Indiranagar. And that playground was being used by children in the surrounding areas, including the slums, etc., to play. What happened was that when there was a proposal to hand it over to a politically connected person to start a basketball academy or something, the local residents protested. They went to the authorities and said, please don't deprive us of this place. But the authorities didn't listen and instead went ahead with doing what they wanted and handed over the place to a politically connected person. And therefore, as a consequence of that, that person started, cordoning off that area and started constructing whatever you want. So desperately, the residents went to the court and they got a stay. And what I'm coming to is that it's not that the general, genuine public interest litigation approaches court first. I can give you several examples where the litigant looks at the court as a last resort, and I'll come to some of those reasons. So my proposition to you, sir, is that in a genuine case, because of the collapse of governance, people see the judiciary as the last resort for getting relief. So would you like to comment on that?
I'm not at all unsympathetic to the points that you've made in terms of dealing with maladministration, corruption, etc. But my point is more fundamental. Okay, let me put it somewhat starkly and simply. You quite rightly said that the administration has collapsed and therefore people go to the judiciary. I would venture a guess that quite soon the judiciary is going to collapse as a result of all these, not just PL, judiciary is going to collapse anyway. But, and we can have an entire session on why that is so, but that's not our purpose. But the reality is that at a practical level, that is going to happen. But at a fundamental philosophical or policy level as well, there are serious questions to be asked, because ultimately, if you believe in the separation of powers, then you have to ensure that each branch of government does its job. And the only solution for a branch not doing its job is the political process. So now I agree, I may sound naive, but believe me, we have to be logical in how we go about these things. As part of the reconstruction of India after 40 years of dirigist socialism, there are pains to be had, no doubt about that. But hopefully, there will be one or two liberal parties coming up with slightly better value systems. And the beauty of democracy is that you can boot out leaders you don't like. Of course, there is no answer immediately to the lack of leaders you may like. There is a problem. I'm not for a moment denying the difficulties. I'm simply telling you that if you go along this route for the indefinite future, then the problems are going to be more than the perceived or intended benefits.
Okay, thank you. The second proposition that I have for you is that, in 2005, the government of India enacted the Right to Information Act. And this Right to Information Act empowered citizens to get information. And I believe it also led to a lot of social change. I mean, my personal view is that. And because of this access to information, the public interest litigations filed by genuine people. Again, I'm qualifying. I'm not talking about people who are not who are more publicity interested or private interest in the whole thing. I think they were able to present to the courts saying that, look, we've done all this, we made representations, and these are the things, and they haven't even considered our representation. These are the file notings or whatever it is. And because of all this, we have come to you. So, would you agree that the Right to Information Act has improved the quality of public interest litigation in India?
No, I would not. If anything, it may have made the situation worse. I am not against citizens getting information. Quite the opposite. Okay, information is power. There's no doubt about that. Just so happens that one of my areas of specialization as a lawyer is media law, and the right to information is very much a part of that broad topic. Now, the difficulty with the right to information is that unless you achieve a proper balance between transparency and the need for secrecy, there are some aspects of governance, of government functioning, which, regardless of how democratic you might be, will have to be kept secret. There is no doubt about that. Now, of course, it all depends on the wisdom of your leaders to carry out administration in a decent way. But the right to information by itself is not a panacea for all the ills. Now, actually, I might mention completely as an aside that one of the crusading prime ministers of my country, a man called Tony Blair, when he wrote his autobiography after wreaking havoc in the country for 10 years, made a startling announcement, a startling statement, and he said, I was an idiot to have encouraged the passing of the right to information legislation. In the UK, it's called freedom of information, not right to information. And he explained why, because it has had unintended consequences. Again, I'm not against the right to information. If anything, we need more information. And I can't also avoid reflecting that India is a peculiar country where, generally speaking, there is a tremendous amount of secrecy. So the instinctive reaction of any bureaucrat to any question is no, regardless of whether the question is innocuous or not. But India is also a country where you can get the top secret information of a kind that you cannot reasonably get in any country if you know how to do it. You want the Prime Minister's personal mobile number? You could get it, but you need to know how to do it. That is not a good thing for a country. Ordinary people should have access to whatever information they are entitled to. But if you have a skewed system, what do? That is the dilemma I would highlight.
Yeah, but you haven't commented on what I said is that the public interest litigations are being more fact based, and they're more focused, and there is evidence based raising of litigation. So, would you like to comment on that? I mean, what is the relation that you see between right to information and the quality of public interest litigations?
To a certain extent, if, for example, if you take a case based on information you've got through a right to information request, quite clearly you are at an advantage compared to a situation where you would not have had that information. To that extent, I completely agree with you. There's no difficulty at all. But the problem here is, why can't that information be used through normal procedures, not of litigation, sometimes litigation, but through normal procedures of governance? Why should you overburden the judiciary to act on this? Because judiciary then strays into areas of policy, which it has no business to do. Just because you present a sheaf of papers obtained through an RTI request, which points to a deficiency in policy making by government, it is not the job of the judiciary then to rectify that. That is the point I'm trying to make.
I think what happens is that people make an attempt with the administration or the governance, and for example, the government notifies a certain scheme and invites public comments. A lot of people, believing in the system, put in comments. And at the end of it all, not even one single comment of thousands received are even implemented. I mean, just put up in some box file and they do exactly what they want. So, because of that, people feel very frustrated, saying, and then they are able to present, saying that it's not that we came to the court in the beginning. We went, we tried with the executive, and they didn't do anything about all these thousands of representations. And they just did exactly what they had proposed in the beginning. So I'm coming to that. Okay, I'll move on to another more practical aspect of public interest litigation. Is that I'd like to understand from you uh, what is the role of the litigant to shepherd a case right from feeling agitated about something to actually going to a court. I mean, getting a lawyer to represent him or whatever it is to the to getting an order and then to make sure that the order is implemented. I mean, is that a lot of effort involved, or what do you think?
Oh, yes, a lot of effort, but also a lot of thinking is involved. So, typically, what happens in the kind of legal system that India has, which is a common law system, which is followed in so many countries, and I don't want to compare India with England. I would compare India with even less developed countries like Fiji or Vanuatu. And I'll tell you that they have a better sense of what belongs where. So, you're talking about litigation. Now, one of the big problems of litigation in India is that, first of all, the filters have been taken away completely. Normally, nobody would be allowed to file a case unless they can show that a right that belongs to them has been violated. Not just make a vague statement of saying I'm agitated. Agitation is not the basis for a lawsuit. You have to show a tangible right that has been violated. Secondly, if you file a case frivolously in any decent legal system, you will be made to pay a price for that in terms of costs. In India, there is no such concept. It is just unbelievable that you may file all kinds of ridiculous cases. Now, I know you might immediately say, oh, there are exceptions. I saw a judge saying pay 50,000 rupees by way of cost. That is really an exception. By and large, people just keep filing cases. And actually, I'm sorry to say this, but there are also, I believe, a few people who are professional PIL litigants. In other words, they probably wake up every morning and say, today, what am I going to file a case on? That kind of a situation is totally unsustainable.
Yeah, yeah, yeah. Okay, one other question that I have for you is, in many PILs, what happens is that the court gives orders, maybe practical orders or impractical orders, and then uh, to it doesn't get implemented, and then the litigant finds it very frustrating. Uh, the only option that he has is to go for a contempt petition. And all this takes time and effort and causes a lot of heartburn for the litigant. And the executive, who are supposed to actually follow the directions of the court, they seem to be totally, thick skinned about it, saying that we'll see what happens because there'll be no serious consequences for this kind of thing. So, in that kind of situation, what is your view on this? Both?
Yeah, you see, there's a limit to what the judiciary can do. Even if I take a very rosy view of PIL, which for the sake of argument I'm willing to take, and you have a pretty decent case that is brought up before a judge, and you have a good judge, you have a judge who is both competent and man of integrity, he passes a decent order. Enforcement is a huge problem because there's only so much that a judiciary can do in terms of enforcement. And it becomes even more difficult in some of these PL cases, which require long term enforcement, not just enforcement in terms of getting something done immediately. And I'll make a broader point, which is not just confined to PILs. India is not deficient in its laws, by and large. There are a few gaps, but by and large, Indian laws are quite good. What is lacking is enforcement. Now, what do you do if that is the problem? I can't think of any solution. No point in saying let us pass more laws. It only makes things more difficult. So
Yeah.
enforcement is a problem.
Yeah, I agree with you. I think enforcement, uh, is the problem. Enforcement also, compliance by the public, general public, is a problem. We want more sticks rather than being able to do it on ourselves. For example, if you see the way the traffic is in Bangalore, everybody is trying to get away with it rather than saying that, if I drive better or if I use the roads better, then things will be better. So that individual kind of responsibility, or cleanliness, for example, you look at garbage, for example. Where is this garbage coming from? It's coming from all of us. But yet we complain saying that garbage management system is bad. We don't even segregate garbage. Most people don't segregate garbage. At least that's my observation. They just, give it all mixed up to the local collector, and that's it. So I agree with you. I mean, but I think a lot of the enforcement also has to be driven from within rather than from outside. Yeah. Okay.
My name is Manmohan. I have two questions, if I may. I'll make them short. The first one is.
Can you ask one at a time so that he?
Can I just, because the two are related.
Okay. Okay.
I'll be very careful with this first point because it concerns a current judge of the Supreme Court. When this judge was a High Court judge, there was a PIL brought before this person saying that the zoning law, sorry, not the zoning laws, the laws with respect to construction of buildings, with respect to how high they can go, how far back from the street they need to be, etc., were being ignored, and the building had come up. Surprisingly, the local corporation concurred with what the Resident Welfare Association was saying, that, look, this is wrong. But they were unable to enforce their own legislation. So the local Resident Welfare Association filed a PIL which went before this judge of the High Court. And the judge said, without even looking at the merits of the case, I don't like PILs. I'm dismissing this with a lakh of rupees in terms of cost. The other point is that you obviously have a bee in your bonnet with respect to Bhagwati and Blair. I won't get into that. But in India, unlike in the UK, for example, we have a written constitution, which is the primary document, if you like, which the judges of the various courts are beholden in terms of upholding. If they stray from that, it's a problem. Now, the first part is the preamble. Now, the preamble takes, the preamble takes precedence over the articles of the thing. So if the preamble says social justice is important, they have to do it regardless of what anything else comes in the way.
So, what is your question? I'm not very
So
sure.
the
On the first
thing is that PILs are not dismissed just like that. They're dismissed partly because some judges like PILs, some judges dislike it. And this judge actually said, I don't believe in PILs. And
I think I know which judge
I know which judge we're talking about.
Yeah, because I had a similar experience with the judge. Yeah.
The other thing is, you were saying that if there are these socio-economic questions, that the Supreme Court or the High Court or the other judges are not required to follow those things. They're not the people to implement it. Now, if you're in a situation where there's a contradiction or perhaps a lack of emphasis with respect to the preamble and the other articles, someone has to do that. And it can only be the judges.
So what is your question? Because I would like him to be.
I think extreme examples with respect to PILs and using that to tar, literally throwing the baby out with the bathwater.
Okay. Okay, we'll take it as a comment rather than a question.
Thank you, Dr. Iyer. Very good session. Thank you. Could you give us some examples of countries who have done a good job of implementing something like a PIL?
I have to say, PIL, the concept of PIL as developed in India has mercifully, from my view, this is my personal opinion, not taken root in any country that I'm aware of. If anything, there has actually been resistance when this has been brought up. Um, an example I can give you is Malaysia. In many respects, similar to India, though of course more developed and all that. And many of the Malaysian judges are of Indian origin. So there's you get that commonality as well. And attempts have been made occasionally in Malaysia to push the PIL agenda unsuccessfully, but uh, both the lawyers and the people have accepted that. Although in Malaysia they did actually allow one type of PIL, they didn't call it that, which was class action litigation. Now, actually, they're two different things, but they're sort of similar. So, that case, which is quite a big case, which went on for a long time, right up to the federal court in Malaysia, which is equivalent to the Supreme Court, it involved what they call the Orang Asli, that is the indigenous people. And there were some orders passed in that litigation, which were seen as very beneficial. I think a proper balance was struck. In other words, between public interest and preserving the sanctity of the legal system. And you can, I support class action litigation where it is justified. And in India, for example, the Bhopal tragedy case is something which nobody can object to if it was brought in the form of class action litigation, because the victims were so disadvantaged. Of course, many of them died and all that. So, no, really, I cannot point to any example where PIL has taken shape in this way. Not even, well, okay, to some extent, Pakistan. So when I go there, I usually discuss it with my friends and colleagues there, and they they actually are trying very hard to emulate India. So they're pushing the envelope very hard in the Pakistani courts and citing Indian judgments, saying, we should do this as well. There's been some activity, but the result has been roughly the same. It's not very well done.
Can I just add to something which he said? I may not be very correct in my reading. This morning's newspaper, the Times of India, had an article saying that a federal appeal court had stayed all these tariffs that Trump has put. And that is as a result of a public interest litigation. So please remember that one of the first countries which started off this public interest litigation concept was the US. And this particular ruling says that Trump has gone much beyond, and it's a public interest litigation. It's not anybody, nobody personally involved in it. So I don't know whether he had locus or not, that kind of thing. But that's what the newspaper report said. And there is a company in the US who handled this case whose focus is public. In fact, I think the name of the company is Public Interest Litigation LLC or whatever it is. So even in USA, there are, and people are trying to stop Trump from doing whatever he wants, and by when invoking emergency powers that he doesn't possess or whatever it is. So I mean, that's just an aside that I'm giving you, but today's paper has that article. Yeah.
Yeah,
Yeah,
very
I can
happy to-
certainly see. I've had a lot of experience in actually doing public interest litigation as a litigant, and there have been many. See, I have done all my litigation, public interest litigation, is by what we call as pro bono work by very good lawyers. I mean, Supreme Court lawyers, High Court lawyers, designated senior counsels, etc., with whom I've had a personal equation at some point of time or the other. They've been kind enough when they feel that there's a genuine case to do it. Otherwise, the cost of litigation can be real burden for you. Even otherwise, it can be not very expensive if you're able to connect with the right kind of lawyers, but otherwise, it can be very, very burdensome. Certainly, I'll share my experience. You may not be able to actually achieve that through. You may have to actually go to a paying lawyer rather than a pro bono lawyer. Yeah. I have a question.
Thank you for the wonderful session. Could we reskin a PIL as a class? My name's Naveen. I'm just a resident. Could we reskin a PIL in terms of a class action lawsuit and then do all the problems go away? And the second part was how much of this is a capacity issue, where if we 100x the capacity of our courts, then this problem goes away.
The answers to both questions, from my point of view, is no. It is not. See, it's not a case of refashioning something into a different procedure. Ultimately, they are two fundamentally different things. The way public interest litigation has been conducted is actually, in my view, a travesty of litigation. So that is out of the question. Class action has a very limited role, where there's a large number of victims. Victims who have identifiable rights. That is important. A lot of the so-called public interest litigation is not based on any identifiable rights. As he was saying, somebody felt angry one morning, let's file a public interest litigation petition. No. And so I don't think it is possible at all. Capacity, it's not going to make any difference. Look at the moment the judiciary is bursting at its seams. Even if you not because only of PIL, there is a general problem, and it was best highlighted by former Chief Justice, a fellow called Balakrishnan, when I don't know how he calculated this, but he came up with this statistic that if no new case was filed, this includes any case, not PIL, any case, it would take the Indian judiciary 384 years to clear the backlog. Okay. Now, he may be exaggerating, I accept. Even if it was 38 years, it's bad enough. And it will never happen because cases are being filed by the thousands every day. And so it's not a capacity thing as well. Of course, there's one point to be made about capacity. If you had intelligent judges, to some extent, the problem would have been resolved. Sadly, that is not the case. I don't want to go into that, but it is a valid point. Not only adjournments. You see, I'm trying to be diplomatic in saying this. You need a judge who at least grasps a case. I'm not talking PL. Any case, commercial case, for example. Unless he grasps it, the case will. What a case should take half a day or even half an hour can go on for 5 days, 6 days. Complete waste of time. Of course, everybody has a vested interest in dragging it on, except the honest litigant. Lawyers are delighted when cases drag on. They get paid by the hour, whatever. Okay. But there have been exceptions. So actually, I want to pay tribute to a man who is no more and who had some connection with Karnataka. A judge called M.L. Pense from Bombay. Pense was an unbelievably good judge. He was a very earthy fellow. So no foreign education. He had a rather simple accent. But what a man! Apart from being utterly incorruptible, which is saying a lot today, he was able to dispose of cases with a smile, where he found something was totally frivolous. And you need people like that. And not surprisingly, he was denied promotion to the Supreme Court.
Yes. Good morning. Thank you for this session. My name is Sitara. I'm a practicing lawyer. And so I do resonate with a lot of what Mr. Iyer said in terms of PILs eating into the court's time and also being a threat to the separation of power. But in my experience, I have seen that, like Mr. Kumar said, it's a final recourse for a lot of people to approach courts. So I'm just wondering if there could be a possible alternative recourse mechanism to address public interest grievances. Could there be a better filter mechanism in courts itself in admitting these matters? Or do you think there could be an alternate body to address these issues? Because I know that a lot of judges do tread carefully in dealing with administrative matters. Some of them refrain from it, but this is a threat. And I was just wondering if there could be an alternate way for us to deal with this.
Without being disrespectful to you, I don't think there is any possibility of an alternative, because handing over these things to a bureaucrat, which is alternative to allowing a judge to handle these things, is only going to make things worse. So, and also in India, there's a further problem. It is this: suppose you had a mechanism of an ombudsman, which is common in some countries, to resolve public grievances. I can bet that most orders of the ombudsman will immediately end up in court. They'll be challenged in court. It's a bit like, I don't know how many of you are practicing lawyers in India. Almost every arbitration award is challenged in India. It's not meant to be like that at all. You know, the whole purpose of arbitration is to get a resolution without going to the courts. So I fear I am pessimistic.
My name is Aban, and a very simple corollary to what the lady has asked is what has been occurring to me over and over. If PILs are not the answer and any other approach is not the answer, then what do we do? I mean, who do we go to address our grievances? Because there are there. If the government doesn't take cognizance of the statements we have made, or objections we have made, or remarks we have made, then what happens? You have legitimate objections.
I understand your frustration because I've been through that myself. And I personally believe that, we go to the court as a last resort, not as the first resort. You try everything, and because going to court is a time-consuming process, it requires a lot of effort, and it may not necessarily give you the solution. That's my view, but Dr. Iyer may have a different view, because I believe I started with that first question saying, because there is a collapse of governance, you are seeing an increasing proliferation of public interest litigation. That is my proposition. The second thing is that we go to courts because we have no other resort, and there are multiple examples I can give you on why people resort to the court in genuine public interest matters I'm talking about. Why people resort to the court after trying every door that they could knock on. Yeah. Now, I have no alternative. I mean, I still believe that, in certain circumstances, given the situation in our country today, PIS are the answer to. That is my personal take. I agree with Dr. Iyer that, the PILs have, from the original concept of a PIL, it has diluted a lot, and it is definitely burdening the court system. All kinds of frivolous, vexatious cases are being filed. All kinds of private interest litigations are coming in the garb of public interest. And people are trying to further their own private grudges. They don't come with what they say, clean hands to court. But still, I personally believe that we have no other alternative actually in this situation. That's my submission, sir.
I don't have an answer to your question. I'll simply say this. You know what? More generally, it is a good idea not to encourage litigation of any kind. That society which relies less and less on litigation is usually a more calm and civilized society. So I'll tell you one thing that is happening in my part of the world, and it is something which I have embraced with a lot of enthusiasm, and I must say with a lot of satisfaction, is this, that we are relying more and more on mediation. Now, of course, we cannot let certain types of PILs be mediated. I don't deny that. But all I'm saying is there is so much room for mediation in India. But mediation only works if there's a willingness to settle, willingness to resolve a dispute. In many cases, there is almost a vindictiveness on the part of litigants. And if you're sitting pretty, you get an interim order, there is no incentive for you to have the matter resolved. And lawyers, of course, I've never seen a country where lawyers are more resistant to mediation. And this is in a country where there's so many disputes which cry out for mediation to be used. So that is, according to me, a practical solution, but I don't think it is going to happen.
Sajan, my name is Sajan. In fact, I'm actually echoing what most people are talking about. What is the alternative? And when tasks are not clearly defined, what happens essentially is a responsibility vacuum or a bystander effect. And I believe, in order to get away with that stalemate situation, you need something to break it down. And I think PIL goes a long way, to break that down, especially, in the instance of Kumar sir talking about how a playground was being hijacked by a well-connected person. There was no way, to shake down that system. You pointed out a fantastic case wherein the Kerala government actually intervened and issued a show cause notice. Of course, you offered your anti-story, about there was no locus standi of the judiciary to issue that show cause notice. But in what way we could have actually saved the life of that little boy or girl who was in need of that medicine? If it was some other country or whatever, if there was no PIL, probably that child might have died.
No, I respectfully disagree. I'll tell you what, India, like many countries, is a country with so much charity. Okay. Now, I know some people might misunderstand me, but I don't mind being frank. This is an example where self-help, the community banding together, would have very easily worked. I don't know what the amount involved was, but there is so much of willingness to help others in India. Even poor people go out of the way to help others. And this should be private initiatives. The other aspect here is, what about societal organization, the churches, the temples, the social institutions? I think it would be underestimating the generosity of these institutions to simply throw in the towel and say the only way we can work this out is by going to the court. I don't even know what happened when that PIL petition was filed in the Kerala High Court. You see, one of my big regrets when lecturing in India is most of the time not being able to talk about how a case has ended. I can talk about how a case began, but I don't know how the case ended, because you never know. First of all, many of them are not reported, and secondly, that case technically may still be going on. So I wouldn't be so pessimistic. There are much better ways of dealing with that problem. Now, look, take the consequence of one of the consequences of what happened there. Suppose the Kerala High Court passed an order saying the government should pay for the medicine. Just imagine how many other people will start queuing up when somebody is ill in their family, not necessarily in Australia, anyway, and say, okay, it is now possible for the judiciary to pass an order for the government to pay for treatment. It doesn't work like that. At the end of the day, it's only going to discredit the entire system.
My name is Abhirath. I'm a law student. My question was regarding the separation of powers doctrine. So as we all know, it evolved in Europe and reflected the social and political conditions of that time in Europe. So don't the conditions in India, the social and political conditions in India, warrant a more proactive judiciary?
No, I don't think so. I'll tell you what, I have some sympathy for the basis on which you have framed your question. And that has to do with whether the governance system that India has adopted is fit for purpose. That's the way I would put it. And on that, there can be a debate. And actually, I would say, if there is consensus for root and branch reform of this system, by all means, change the system. But don't try to impose unbearable strains on the system, which will lead to one of the branches or more than one of the branches collapsing.
I think the point that Dr. Iyer is making is that, unless you have a clear separation of the various arms of democracy, the judiciary is taking upon itself not only to administer law, but actually to dictate what law should be, and which is a dangerous thing for democracy by and large. But then what is the answer? You see, we don't, because the other, if you look at the political system or the executive system, they seem to not accept what their role is, and they don't. I mean, in fact, they seem to be constantly trying to find a way of, let me say, deceiving the public at large. So when that happens, then people say, "Oh God, I mean, I have no other alternative but to go to the court." And let me tell you one thing: that it's not that every time you go to court that you will get a successful ruling. Okay, it can be very frustrating. You spend a lot of time, lot of effort, whatever it is, and then ultimately you may not get an order which is favorable to what you wanted. And then what happens? You go to Supreme Court, and then High Court, Supreme Court, and then all this costs time and money and effort, and so don't think that a public interest litigation is a magic wand. That it's a panacea for all ills. It will not happen that way. Yeah.
My name is Ajay. I'm more like a philosophy guy, so this is all too new to me. So the question might be wrong, but as he said, a person can just wake up in the morning and just say that the door has a wrong sign, so I'm filing a PIL case. So I believe that a human does this, a person does this because of a human tendency of self-interest or urge to be in control or fear. So what can be done to avoid this? Because this is taking a lot of court's time and taxpayers' money. So this.
Yeah, it's a very simple thing. The system that currently encourages that kind of indiscriminate litigation will have to clamp hard on people who attempt that. So it is not impossible. That is not difficult. You need judges who are both intelligent and forceful in preventing the abuse of the system. Almost as an aside, I'll say in relation to what you said, I actually read some years ago of one of these inveterate lawyers who specialize in public interest litigation, actually boasting that he was in the Limca Book of Records as having filed the largest number of PILs. That is the kind of nonsense that is happening. I mean, in any other country, people would be outraged, whereas there are many people who go and felicitate him for that record.
How much of an extra burden has PIL imposed on the judicial system? You see, the judicial system was already breaking down before the PIL business began, if I can call it that.
At least my answer will be, I don't know, in the sense that no proper study has been made. This requires a lot of effort to actually go into, for example, sift through the cases. And even there, you may not get an accurate estimate because some of the cases may not strictly be public interest litigation. In some of the cases may actually then be transferred to other jurisdictions, etc., etc. I don't think, I may be wrong, but I don't think anybody has made a thorough study to say, for example, that public interest litigation cases constitute 23% of all cases, all civil cases filed in the Indian judiciary. I don't think anybody has carried that out. It will be good actually if some research organization is able to do that, at least to the extent of giving people a clearer idea of the extent to which this is draining away resources.
Thank you, Dr. Iyer, for a very illuminating conversation that we've all had. Thank you for your inputs. I think people are going to go back with ideas on what they could do and where is the way forward for handling their particular situation. Thank you. And I want to thank BIC for inviting both of us to be here. Yeah.